Hi, I'm Jason Sullivan of Rathbone Group, and this is On Subrogation, your free video resource to assist with your subrogation and recovery claims. This video, we're going to talk about attorney fee shifting. The general rule in the United States is that each party pays for their own attorney fees, no matter who wins in the outcome of the case. There are some distinctions and some exceptions to this general rule. The first is when it's by statute. Many states, and there are federal statutes as well, that have created rules that state that the party who wins or prevails in the action is entitled to have their attorney fees paid by the other party. Many times these rules are put in place because we want to encourage parties that may not have the resources to pursue a claim to be able to pursue that claim and have attorneys represent them, and the attorneys are able to be paid. In some cases, the fee shifting is mandatory. In other cases, the court has discretion. One of the most important fee shifting rules for subrogation and recovery cases is an offer of judgment. Under the federal rules of civil procedure, this is Rule 68, and many other states have adopted similar rules to this. The way the statute works is a party may make an offer of settlement or offer of judgment to the other party. They're offering to either accept a certain dollar amount to resolve the claim, or the party's going to offer a certain dollar amount to resolve the claim. In these cases, if the party to whom the offer is made does not accept it, then the clock starts running, and from that point on through the end of the litigation, they may be on the hook for attorney fees if at the end of litigation they don't prevail and do better than what the offer of judgment is. So, take a disputed automobile case. The plaintiff has filed suit, the defendant files an answer, the case is going through discovery, and at some point the defense attorney says, we're going to make an offer of judgment, we're going to offer to pay 60% of their claim balance. The plaintiff then receives this, and there are different rules on how it has to be presented and in writing and how it's presented to the plaintiff. The plaintiff gets it and says, my case is worth way more than 60%. There's not a chance I'm going to accept this offer of judgment. The case proceeds. Maybe they do depositions, they have experts. It goes on, and it goes to a trial. And at the trial, the jury finds that the defendant was only 55% at fault. Now, in some jurisdictions, that difference between the 55% at fault and the 60% offer of judgment is enough that, because the plaintiff, if they would have settled, they would have done better. Now they're responsible for all of the attorney fees from the date of either that offer of judgment or the date they reject it, or a certain time passes and it's deemed rejected. In those cases, then, the plaintiff would have to pay for the defense attorney fees incurred during that time period. And as you can imagine, those could mount up if the litigation went on for months or even years after that offer of judgment was made and then rejected. Another area where attorney fees may shift is where the court has the authority to issue sanctions against another party. The purpose of this fee shifting in this case is we want to use these to govern parties' behavior. Courts will have discretion to award sanctions against parties who maybe pursue claims in bad faith, or bring frivolous actions or frivolous defenses, or refuse in good faith to participate in the litigation process, specifically in the exchange of discovery. A particular example of this would be if a suit's been filed and it's in the discovery process. The defendant makes a reasonable request to the plaintiff's attorney, and the plaintiff's attorney says, no, we're not going to give them these things. They fill out a privilege log and say, these are the items we're not turning over, and this is the reason why. Well, the defense attorney disagrees and thinks he's entitled to that under the civil rules, so under the rules, he goes to the plaintiff's attorney, they have a discussion, they confer about it, and plaintiff's attorney still is not going to turn it over. Defense attorney gives him another option, and then files a motion to compel with the court. A motion that asks the court to say, we believe we're entitled to this, and you need the court to issue an order to turn this over. The court reviews it and thinks that the plaintiff's position is not well-founded and orders the plaintiff to turn him over. Usually, if the plaintiff turns him over at that time, a lot of times attorney fees can be avoided, but not always. And if the plaintiff still doesn't follow the court's order, then courts are especially quick to award attorney fees because plaintiff brought forth a claim that they didn't have to turn information over. The defendant tried to resolve it, they couldn't resolve it, The court ordered the plaintiff to turn it over, they didn't turn it over, and the court had to get involved again. And the court doesn't want attorneys and litigants to behave in this way, and so they use sanctions and the shifting of attorney fees in these particular cases to penalize parties and prevent them or try and incentivize them to not engage in that type of behavior. A third exception to the American rule on fee shifting is by contract. And for subrogation and recovery cases, most of the time we're not dealing with a contract. But there is one big exception, and that's for insurers that are members of intercompany arbitration. Now, that's a contract that carriers have agreed to be a part of, and they're going to abide by the rules. Under those rules, if there is an award and a party is ordered to pay, there's a certain time frame in which they must make that payment. They have 30 days from the date of the award to issue payment. If they don't issue payment, the winning party then has the right to send a letter asking for the payment to be made. If another 30 days pass and they don't issue the award, then that winning party can go to our forums, who will then coax the losing party to go ahead and abide by the agreement and pay. If another 30 days passes after our forum's intervention and it's still not paid, the winning party may pursue through legal action to have that arbitration award enforced and seek the costs and attorney fees. And so in this case, the attorney fees are allowed by contract because the parties have agreed to have that happen. If you're looking at intercompany arbs, that's Rule 5.2 that allows the fee shifting for attorney fees when certain conditions are met and the losing party fails to pay. One issue that comes up with attorney fee shifting is, how do we calculate the attorney fee? The most common way in the United States is through the lodestar method. This takes what is a reasonable attorney fee and multiplies it by the hours of work. In a contingency fee scenario, you can see the issue that this may cause, and courts are very reluctant to award attorney fees when it's just a lump sum dollar figure at the end. They want to see the hours of work that was put in. If you're a contingency fee attorney, you may not be used to calculating the amount of time and effort you put into the file. But if you're going to think that your client may be entitled to attorney fees at some point down the line, it's important to have a good, strong records of the time and effort put into that, as well as knowledge of what is a reasonable attorney fee for the type of work that's being done. If you have any questions on subrogation materials or ways to pursue claims, please contact us at video@rathbonegroup.com. If there's a topic you'd like to see us discuss, we're more than happy to put that together for you. I'm Jason Sullivan of Rathbone Group, and that's the long and short of it.